Good day, good evening, good morning, wherever you are and whenever you are, I greet you digitally. I'm Charlie Rose, and this is the Trial Advocate. Right now, we're engaging in one of a series of presentations on the 4 pillars of ethical practice, the formation of professional identity, and the ability to keep yourself as the lawyer out of jail. You should remember that there are 3 primary rules of practice that you always want to keep in the back of your mind. The first rule is to get paid, preferably up front. The second rule is that if you get involved in a criminal proceeding and your client's in trouble, it is always better for your client to be a witness as opposed to a defendant. You could perhaps watch some of the things that are happening in the news with the special prosecutor right now and see how that's playing out. And then the third thing is that if anybody is going to jail at the end of the day, you need to make sure that it's the client and not the lawyer, So today I'm going to talk with you about conflicts of interest. I want to get involved and look at the rules of professional responsibility as they relate to conflicts of interest. And my goal is to review it for folks who thought about it before and who are maybe watching this video for CLE requirement, and then to also develop some thoughts about it from a practice perspective, from those of us who are in the day-to-day practice of law and have to deal with conflicts of interest issues, and then to finally maybe help some law students who are studying for a professional responsibility exam somewhere or who are getting ready to take the MPRE and may have been confused when they went through the conflicts of interest block of instruction. Conflicts of interest can be confusing as a subject when you first approach it, because the conflict of interest in reality, in application, is defined by the relationships between the folks involved in the issue, but it's not always taught from a relationship perspective. And so you can read the rule, understand the rule, and still perhaps not be able to apply the rule. And my goal today is to get you to a place where you can apply it, where you can do it, where you can use it, regardless of your previous understanding of it. And most lawyers will tell you that conflicts of interest rules are very important rules from the standpoint of getting paid, of continuing with litigation, of being able to represent. So let's dive right in and think about the types of conflicts of interest that exist. If I step back from the rules and I read them holistically, and I look at the practice of law, I discover that I can have a conflict of interest with a client or a potential client, prospective client, based upon an interest of my own, a duty that I owe to another current client, a duty that I still owe to a former client, or my duties to a third person. In each of those instances, I can potentially be unable to represent this prospective client or current client when there is that conflict, right? And so what I need to do as a lawyer is to look at these 4 potential areas where conflicts of interest can arise, and then I need to go back and review and look at the rules in question so that I understand the connections between the two, and I can keep myself out of trouble and continue to get paid. There's a policy behind these conflict of interest rules, and the idea is that we have a duty to exercise independent judgment. We have to be loyal and diligently represent the clients that we currently have, and we have to preserve those clients' confidences. And when I have clients who are against each other from a conflict of interest perspective, what I know about one could potentially be used by the other if they knew it. And these competing interests create conflicts. Usually it's between one client and another. Sometimes it's between a client and a third person. And sometimes it's actually between the client and the lawyer. In each of those instances, I am able, when properly oriented, to identify potential conflicts, avoid them where possible, get permission despite the conflict of interest when necessary, or terminate or not engage in the representation where appropriate. And these are things that we need to be able to do. Some of the things that can happen to you if a conflict of interest is discovered later is you can be sued for malpractice, to include damages. You can be disqualified from the case. You can be disciplined by the bar, and you can have your fee forfeited. You can have your fee forfeited. I will say that for the third time. They can take your money away. And so we need to make certain as we form these client relationships that conflicts of interest do not exist so that we can stay out of that sort of financial trouble. A lawyer cannot represent a client if the representation involves a current client, a current conflict of interest. And the rule talks about this as a concurrent conflict of interest. And it says that we have these if, one, the representation of one client will be directly adverse to another client. So when one client's representation is going to hurt the other one. When I represent one and somebody else comes in and wants to sue the one I represent, for example, that's where we're dealing with two current clients. Or there is a significant risk that the representation of one or more clients will be materially limited, and I'd underline that, materially limited by the lawyer's responsibilities to another client, a former client or third person, or by a person or by a personal interest of the lawyer. This is the material limitation rule. And you actually look at the substantial risk of materially limiting the lawyer's responsibilities. And we'll talk about that as we get in through. Now, the lawyer's client is ordinarily the person or entity that consents to the formation of the attorney-client relationship, not the attorney. We form that contract with the client, with the prospective client, but it's their consent that is key. And because it's their consent that's key for the formation of the attorney-client relationship, their consent becomes a key issue when we're looking at limiting the scope of representation or when we potentially have a conflict of interest. We're going to have to get their permission, for want of a better word, right? So when could a lawyer's conflict of interest obligations extend to non-clients? You know, when could I have a situation where, my God, it's not a conflict of interest between my clients, either current and former, but it's to somebody else? Well, look for financial relationships that create a liability. Look for personal relationships that create this possibility. And the question that you ask is whether or not loss or benefit to the non-client person or entity will have a direct adverse impact on the client. And in those instances where it will, you may have a duty to inform and seek a waiver if possible, or you may need to withdraw from the representation completely. One of the questions that often comes up is the ability to consent to future conflicts. I take a client in, I say, hey, look, I represent you, but we may have some conflict of interest down the line that I don't know about yet. I'd like for you to go ahead and consent to that conflict of interest, whatever it may be, so that we can move on down the road with this litigation. And because of the power dynamics between lawyers and clients, clients will actually do that in a lot of circumstances, particularly if it's just a general consent without specificity. What do we look for? Open-ended agreements about consent to conflicts of interest are usually void. They're not valid. You look to see whether the client possesses sophistication and as the client had an opportunity to receive independent legal advice about the consent. In fact, before I'll ask for consent to a future conflict, I don't give time for, I require the client to seek private legal advice and to inform me when that has occurred, because I'm concerned about the potential blowback from this issue. Now, what about when I have a continuing lawyer-client relationship? You know, they're my client, they remain my client, and I'm sort of expected to do things for them as they come up. So they're a current client, it's a continuing relationship. I know that I have a continuing relationship if they don't require an engagement letter for each new matter. In that instance, consent to potential future conflicts makes sense because it can help that client who wants that ongoing relationship. And then this works when we've got informed consent in advance to the type of conflicts that the client is familiar may occur. So you've got a sophisticated client, they need an ongoing relationship. You're not doing an engagement letter every time you do some work for them, and they know the types of potential issues that may come up. In that instance, we look to see, does the agreement effectively protect the client's rights? And if it does, will allow you to engage in that consent against future conflicts of interest. Well, why do we have this conflict of interest rule? Undivided loyalty instills trust. I'm your lawyer, no one else's. That has power. It enhances the effectiveness of representation because it ensures the independence of the lawyer. There aren't going to be outside forces that the client does not control influencing what the lawyer will or will not do. Practically speaking, there are always outside forces that the lawyer considers, but that doesn't necessarily mean that they control what the lawyer does or does not do. It just means they're thinking about it, and that's okay, right? It allows us to safeguard the client's confidential information in a way that we could not otherwise do when we have conflicts of interest, and it prevents us from exploiting clients. We can't exploit one client, play one client against another for our own benefit, and it does ensure the continued existence of the adversarial system, which is to a certain degree a foundational component of what it means to be a lawyer in the United States. It's actually to a certain degree a foundational component of what it means to be a lawyer in all of Western society. This idea that somebody has your back and no one else's. This idea that I have a champion, that I have an advocate who will speak on my behalf, who will speak truth to power and won't be influenced by anything else that's out there. This is a powerful idea, and it's an important idea for us to keep, particularly in a democratic society. And lawyers actually help ensure that, and the conflict of interest rules is one of those places where it happens. So when do I have a conflict of interest? If there is a substantial risk that representation of the client would be materially and adversely affected by my own interests or my duty to another current client, a former client, or a third person. That's the beginning checklist for determining whether or not conflict of interest exists. Once I've determined that, then I need to look at the different types I should have. The first one are my own interests, right? Normally, my interests could create a conflict of interest if we're involved, we have interest in the same matter, or when unrelated representations are such that my relationship with one or both clients could be adversely affected. And so I've got conflicts there. And I have to be concerned about those ahead of time. So conflict of interest standards require you to answer 4 specific questions. You need to know what effects are prohibited. You need to understand how significant the effect must be to determine whether or not the conflict of interest is valid. You have to understand what probability exists that the potential effect of the conflict of interest will occur. Because some conflicts might be possible, but they're not very likely. Others are almost guaranteed. If I'm representing 2 defendants in the same criminal action, I'm going to have a conflict of interest between the 2 at some point. And that's something that the rules have to take into account. And then from whom's perspective are conflicts of interest to be determined? And that's the client's, particularly the current client, sometimes the former client as well. So that's where we're really looking when we're thinking about conflicts of interest. The rule mentions this idea of materially limited, this material adverse effect. We look at the obligations of the lawyer. We look at the obligations to the client by the agreement. We look at the retainer agreement. We look at what's occurred over the course of representation. And we say, is it going to materially affect, is it going to adversely limit my ability to accomplish what I have promised to engage in? And if it's going to materially limit it, I have an issue. Sometimes it's really not a material issue. It's really not going to have an adverse impact, but the client has in writing said, hey, look, I consider this to be a conflict of interest. When that occurs, the conflict is defined by the client. And if the client thinks that it creates a conflict of interest, then it is a conflict of interest. Even if legally speaking, there's no real impact. And so you have to be aware of that. The client's wishes control when dealing with these issues. What is adverse? It's the quality of the representation, not necessarily the quality of the result obtained in a given case. It's not that you're guaranteeing an outcome, it's that you're guaranteeing a process where you're putting your best foot forward as the lawyer for this person, where you're engaged in the activity that makes it work the right way, that ensures the guarantee of justice. That's what we're looking at. How is substantial risk defined? It's just the likelihood of the effect. Usually it's immediate, actual, and apparent, but sometimes it's significant and plausible, but it might not even be likely. The standard requires more than a mere possibility of adverse effect. So a mere possibility, we're not going to have a problem, we're not going to have a conflict of interest. If there's a substantial risk that is significant and plausible, we probably have a conflict of interest. And if it's apparent, actual, immediate, we have a conflict of interest. So those are the three bands where we're looking at potential conflict of interest issues. Can conflict of interest be waived by the client? Yes, it can. But in order for that waiver to be viable, it has to be based on an adequate understanding of the nature and severity of the lawyer's conflict. It cannot violate law, and the client must have the ability to consent to it. The client must have the ability to consent. And if it's based on an inadequate understanding of the nature and severity of the conflict, or it violates the law, or the client lacks capacity, the waiver is not going to be valid. The waiver will not be valid. And this is it reflects contract law. It even reflects knowing, intelligent, and voluntary from the standpoint of some aspects of criminal procedure from a constitutional perspective. This is a relatively comfortable standard that you should be familiar with as a lawyer. But it's important that we understand that we have to inform our clients sufficiently that they see the nature of the conflict of interest and the severity of the conflict. We have to make certain that if we're asking them to waive the conflict, that it doesn't violate the law, and we have to make certain that our client actually has the ability to deal with the conflict to begin with. Client consent has to be free of coercion. The client has to make this decision of their own volition, and we can't push them to make the decision. We can push clients to make decisions through the use of time, through the use of circumstance, and we don't want to do that. Sometimes, though, conflicted representation cannot be cured by consent. When? If it's not reasonably likely that I'm going to be able to provide adequate representation to the affected clients, when a client face each other in the same litigation. I can't represent both sides in the same litigation. That is they are immediate, apparent, and adverse to one another. I can't have confidentiality with one, confidentiality with the other. We just don't allow it. It's not functional. This really shouldn't bother you as a lawyer, because the times when you might be asked to represent two folks against each other are extremely remote. And by requiring this rule, it ensures that at least two lawyers get hired whenever there's a conflict between two people. Limiting the scope of representation. Sometimes limiting the scope of representation can be used as a tool to avoid what might otherwise be a conflict of interest. I may have a client that I represent in real estate matters, and then I might have another client who wants to sue this client for a tortious issue. I may be able to form a scope of representation agreement that allows that activity to happen both ways. I'm not suggesting that that's a good idea. I'm not recommending it as an approach, but But objectively, if I can do it without rendering the remaining representation inadequate, it may be possible. It's not, though, a best business practice for a variety of reasons, and you always run up against the possibility that whoever looks at it after the fact is going to look at it through the lens of it all went wrong, and perhaps you should have seen it to begin with. So limiting the scope of representation is a possibility, but it's not a preferred modality unless you have some really valid reasons for doing so. Sometimes I can withdraw from representation because a conflict of interest rule prevents me from doing it. And that's perfectly appropriate. Withdrawal is an interesting animal in and of itself. I can withdraw if a client wants me to commit to engage in criminal misconduct, if the client wants me to engage in conduct that I find repugnant. And I can do a couple of types of withdrawal. I can quietly withdraw, or I can noisily withdraw. And a noisy withdrawal in the literature and in the law revolves around the idea that while I have a duty to maintain the client's confidences, I can't allow the client to use my services to commit a crime or fraud. And in those instances where I believe or know that to be happening, I withdraw noisily, so I'm putting on notice everyone who might have known that I represented the client that I'm no longer representing, to ensure that any work that was done by me doesn't go forward as a basis for additional fraudulent activity. When deciding whether to noisily withdraw or quietly withdraw, it's often useful for lawyers and for firms to seek the advice of competent counsel on this issue who understand the law in all its complexity, because you're bumping up against the confidentiality rule as it applies to the client. So how should I approach when I'm dealing with conflicts of interest? Well, the first thing I ask is, do I have the client? What is the scope of representation? Are there potential conflicts of information based upon the client and the scope of representation? If necessary, will the parties give informed consent? Does the rule allow for informed consent? Has the informed consent been done properly? And have I considered the likelihood of future conflicts? This checklist is a really useful checklist to keep you out of trouble and to address conflict of interest issues on a bar exam or in some other modality. So I've talked with you in conclusion here about conflicts of interest with current clients, between current clients and former clients, and between current clients and lawyers. The checklist that I gave you at the very end of this particular presentation is something that you should crosswalk with the rules on conflict of interest that you find in the chapter on conflicts of interest. It's usually 1.7, 1.8, 1.9 in most conflict of interest codes. We can't represent two clients at the same time. We can't have two masters. We can't serve two masters as a lawyer. We can't advocate zealously for one client while simultaneously hurting the interests of another client. To a certain extent, this is common sense, but when it comes up at court, it's complex because of the case law, and when it comes up on the bar exam, it's a little bit aggravating because of the way the rules for current, former clients, and prospective clients interact with one another. I suggest to you that you go back and look at those rules, that you review them whenever you have to deal with issues like this, and that when in doubt, talk to another lawyer. Till next time, I'm Charlie Rose, and this is the Trial Advocate.